In the matter of Johnson versus Roselle, EZQuick LLC, can we please have appearances of counsel?
Your Honor, James C. Mescall, Mescall and Costa on behalf of the plaintiff appellant.
Good afternoon, Your Honors. Curtis J. Cookman,
Welcome, counsel. Mr. Mescall, you may proceed.
Thank you. Your Honors, I had initially requested 5 minutes to give my statement, but I would prefer to waive that. I think I can better serve the court and my client by answering any questions. As the court knows, this involves a statutory construction of the NJSA 39-6A 9.1, a statute that allows the insurance company a direct right of action against the insurer of a tortfeasor in order to collect no-fault benefits which they've paid to an injured party. The case that governed this dispute was, of course, the Fernandez case, which eventually held that the insurance company had priority. My claim, of course, involves the amendment to that statute, which was passed on January 28, 2011, signed into law.
You waived your opening argument?
Yes.
Before you even get to that,
Okay.
do we have a question of like what we haven't decided Fernandez, have we? It was 3-3. So that decision was non-precedential, at least to us. So as far as I can see, we're not bound by that decision. Am I correct?
I would agree with that, Your Honor.
So do we have to first resolve that issue, the Fernandez issue? Like, why do we even, if the old law favors you, why do we even get to the amendment?
We don't. It's a very good point. I think that's something that I certainly overlooked here. This court is free to decide this case. It was a 3-3 decision.
But aren't you here on a dissent?
I am here on the dissent.
So you're limited to the issues raised by the dissent, are you not?
Yes, that's what the court rules say, Your Honor.
Thank you.
And wouldn't we look to the state of the law at the time the amendment went into place and try to interpret that?
The state of the law at the time of the amendment went into place. Well, I think that Fernandez was accepted as the law, even though it was a 3-3 deadlock. I think I agree with Justice's statement that it doesn't bind this court.
No, so we have to look to the appellate division decision. There was no precedential ruling by this court, right?
Correct.
So you have the appellate division of Fernandez,
Yes.
you have Knox, you have David. Didn't the amendment change settled law that had been set forth at the appellate division level?
Well, I tend to disagree with that in the sense that, we have the IFA case versus Watt, where the insurance, the proceeds of the liability policy were paid to the injured party, and then the no-fault carrier came back and said, we want to collect from the tortfeasor's liability carrier, and the court said, you're too late. I mean, there were some limitations there in the sense that if the insurance company wanted to get paid first, they had to win the race to the courthouse. There was also some very strong language, I believe it was in the David case, that was somewhat critical of Knox and questioned the Knox holding, though it did follow it ultimately. It said Knox could have been decided either way. In other words, part of Geico's argument here is that we had settled law that we relied upon, and I would respectfully submit to the court that it was not very well settled. This has been an issue that has been out there for a while. I've been a member of the plaintiff's bar for a long time, and we waited for quite a while for that to get to the Supreme Court, and it was something that, was of great interest because we didn't feel that the issue was firmly settled, though certainly I have to agree, Your Honor, that the decisions that were made said that the carrier, the no-fault carrier, has priority. There were no cases in the appellate division or in the law division that I found that said the plaintiff had priority over the no-fault carrier.
And the legislature.
It won't surprise you that I thought Justice Long wrote a wonderful opinion, but that's not the question before us, is it?
No, and I think it does come down to the statutory intent with regard to the amendment, whether or not that was intended to be retroactive. And I think that you take this, if you know the history, as obviously this court does, you know the effect of the ruling in Fernandez. It's very clear that the legislature disagreed with that interpretation of the law, The amendment was passed. It was unanimous. I think it was 75-0 in the Assembly. It was 37-0 the Senate vote. And you know, that is part of the puzzle here. You know, this went fairly quickly through the legislature. We have the statements of the sponsors. I can go through some of them. I'm sure you're all familiar with them. But they felt very strongly about this. I mean,
And they felt strongly about it at a time that was very different when the act was originally passed, and people were very concerned about additional burdens being placed on automobile insurers. Therefore, the right of access was included originally in the statute, at least according to the Knox Court, the David Court, and the majority, well, 3 people in the Fernandez Court.
You know, this is, the no-fault laws, it's a law of reparation. I mean, it's meant to protect the plaintiff. Certainly the 1983 passage of this statute was meant to save money for the insurance companies.
But for PIP, the question was, how do you get money for medical benefits quickly and easily to the injured person? And the determination was PIP was going to pay it, but there was going to be possible reimbursement to the insurer.
And I don't know that it was foreseen when the bill was passed originally that we're going to leave somebody, quote-unquote, holding the bag here, the injured party. The example being, if this had been a situation where there's $250,000 in liability insurance.
But the point is, since 1997, the legislature knew that that was the interpretation being given to that statute that had been passed several years before that and had been implemented consistently in that respect.
I don't know that I necessarily agree with that because of the language in David, because you had to win the race to the courthouse. I don't see this as definite settled law. I think it was questioned.
Well, in this case, we're focused on whether or not this is curative legislation, are we not, based upon the dissent?
Yeah.
Because the dissent and the majority both agree there was no express or implied retroactivity from the legislation that created this amendment.
I don't agree with Your Honor. I certainly agree that there was no express statement by the legislature.
Where did Judge Ashrafi say that there was implied retroactivity?
Well, I'd have to look at the opinion, but my reading of the opinion is he said it was certainly curative and it was implied. He said...
No, he said it was curative. And he also addressed whether or not there were expectations of the insurer that would be unsettled by applying a curative amendment.
He said, and I'll quote from his opinion, one fact that is absolutely clear from the majority's discussion of the legislative history and the language of the amending legislation is that the legislature did not agree to any delay and wanted the amendment to be effective immediately as of January 28, 2011. I think
Right.
a fair reading of that statement is it was implied.
How can that be so? It's an occurrence policy.
Excuse me?
It's an occurrence policy, so how can it be so that effective immediately is going to relate to any claims that had been brought before?
The courts have
Judge
done...
Ashrafi was focused upon the accrual date of when the PIP reimbursement claim could be brought, but I think, respectfully, I'm not sure that you're properly reading the dissent in terms of implied retroactivity as between the dissent and the majority.
Yeah, it's always been the plaintiff's position here that this should be what we call pipeline retroactivity, that when they said effective immediately, they mean claims that are pending.
Do you have an argument that you win if it's applied prospectively? The amendment went into effect on January 28, 2011. The plaintiff did not file its third-party lawsuit until June 10th of 2011, and GEICO did not file its cross-claim for PIP reimbursement until after the amendment.
That's correct, Your Honor.
So when the legislature said it wanted it effective immediately, meant then. That was before GEICO did anything.
Well, isn't
So
that why the accrual issue is before the court?
Excuse me.
Sorry.
So why wouldn't a prospective application, if using that date, and the fact that GEICO had not moved, not benefit you?
It does, and I think that this is, we're splitting hairs, definitional hairs here. Whether we say it's a prospective statute that becomes effective immediately.
But that is not within Judge Ashrafi's dissent in the case. Isn't that a fair statement?
I don't believe that's a fair statement, Your Honor, with all due respect. I think that what he's saying is,
He's saying it's retroactive because it's curative. Isn't that what?
It definitely says that. I think the language that I just read is saying what the legislature wants is for this to become in effect immediately. In other words, to apply to pending claims, to apply that anything's that's still out there. Now, we can call this retroactive, we can call it implied retroactive.
Well, there's a distinction between the argument that Justice Albin raised, which is that it's prospective based
Yes,
upon
I
the timing of the
understand.
claims, and the argument that Judge Asrafi made in his dissent, which is that it is a retroactive
Well-
statute because it's curative, isn't there?
Well, I'm reading
Let me
from
just hear
page
from
two.
counsel.
Page 2 of his
just hear
dissent
from-
actually has exactly what I stated.
Okay, just want to hear from counsel.
Yeah, and I think quite honestly that both arguments can be made. Judge Ashrafi certainly said, and I think that this is what the legislator wanted. They said, we want this to be effective immediately. And if you call it retroactive implied, or you call it prospective as of the date that the statute went into effect, and the fact that GEICO hadn't acted on its rights and had to file a complaint,
You have page 2 of the dissent? And tell me if
Sure,
I'll read it, and you can tell me if I'm reading it correctly. In this case, GEICO's right to reimbursement did not exist until August 2012, when plaintiff and the tortfeasor settled plaintiff's claim. At that time, the amended statute was in effect, and it required that plaintiff's claim be paid before GEICO would be reimbursed from one beacon policy. The trial court was bound to apply the amended statute when it decided the summary judgment motions in March 2013. So that issue was presented by Judge Ashrafi.
yes, Your Honor, I believe so. And, we've had other similar situations in Kornblatt where the question was, well, when does this affidavit of merit statute apply? Does it apply at the time the complaint is filed, or does it apply to cases that have accrued before that? So, this issue comes up, and generally we have issues on accrual, and I have no quarrel with GEICO's position that we had an accrued claim in the sense that a PIP application had been filed. I think it's the Holbrook case that says that's what's accrual in a situation like this. But what trumps that is legislative intent. And I think we can get lost in the minutia of this, but the guiding factor in deciding this case is, what did the legislature want? And I think if you look at that as a whole, it's a puzzle that you piece together. You look at what was the underlying claim. There was such great unfairness to somebody who might get no recovery, who had a serious injury, that, again, the votes were unanimous. They looked at this and they said it's something we disagree with, that we need to correct. It was certainly curative. I think Judge Ashrafi found, and this was implied, given all the legislative history that we have. And that trumps everything. There can be technical arguments about accrual, but one thing I think we know is that the legislature can pretty much, do what it wants in most circumstances, and this is one of those circumstances. They can change established rights to some degree. The whole insurance setup, there's I think a statement in James, it's a quote from another case, it says it's a very fluid, highly regulated industry. It's not something that you can rely on. But taking everything as a whole, legislative intent is the guide. We have two sponsors who felt that, listen, we can't have this situation. We insure to spread risk. And now we have a whole, insurance system, and we're leaving somebody who is severely injured, who paid for insurance, or paid for no-fault coverage, and they're left, quote-unquote, holding the bag. They don't get a recovery. It's just not acceptable.
And the amendment was filed before GEICO sought reimbursement.
The amendment was, yes. The amendment was passed before they filed a lawsuit, but certainly before the case was settled,
So the question is
obviously.
whether or not GEICO should therefore was at that point forbidden based upon the law that was on the books.
That's correct. That's correct. So, everything considered, I would respectfully submit that there were arguments in the hearings. Hey, can we hold off on this? The insurance representatives who spoke said, we're not sure of what effect this is going to have.
The filing was August of 2010.
That would have
the
been
claim.
the filing of the PIP application.
The PIP application,
Right, but-
and that was 4 months before the enactment of the statute.
Yes, Your Honor, that's correct.
Or the amendment?
Yeah, the complaint, the third-party complaint answer of Geico was filed after the amendment, and of course, the settlement was reached with one beacon after the amendment became effective. The other thing is, this is not a cruise case. I mean, this, if the court opts for, assuming it's retroactive as the court defines it, we're talking about a pipeline with a trickle in it. The statute has been quote-unquote corrected by the legislature. These issues don't come up, as the legislative history indicates, they're rare occasions. I mean, often the statute works for everybody in the sense that, the plaintiff gets full compensation, and the insurance companies, who usually have a $250,000 limit with the PIP, they get paid back too. So it's a relatively rare occasion. And this is not a situation where, such as cruise, where in workers' comp you can reopen cases. That's not the case here. Quite honestly, your decision probably only affects one man. Since the time that this case was accepted by Your Honors to hear, or the request for the appeal was filed, I've heard from one other attorney who has a similar case.
So
Now, the majority pointed to language in the statute that refers to the claim, the ability to seek reimbursement from the claim, to the language in A that says it has to be filed within 2 years of the filing of the claim, and then imports that notion of claim down into subsection B. All of that relates to the date in which the PIP claim is originally filed with the carrier. Is that not correct?
That is correct. I mean, that's the accrual date.
Right.
And again...
So why was the majority in error to have applied that as the accrual date for implementation of this statute?
Because it wasn't what the legislature intended. I mean, the legislature can say the claim accrued, but we're going to eliminate the claim. I cite I think it's the Maker or Meeker case, which has to do with the palimony. It was an appellate division case where there was a statute that was passed, and the question was, we've had palimony for 30 years, and basically the legislation, which was an amendment to the statute of frauds statute, said, hey, listen, you got to have a written agreement, and you got to have, both parties have to have independent counsel, and in effect, it wiped out 30 years of palimony.
Actually,
claims.
this court heard that case.
Did hear it, okay.
A little bit apples and
mistake.
oranges.
There was
though.
an opinion written.
Yeah. I mean, my point, Your Honor, excuse me, it was a brilliant decision.
Did you write
But
that?
excuse me, my point here is that the claim can accrue. And remember, this is not a claim against my client. This is a claim against an insurance company, another insurance company. And the claim can accrue, but the legislature can affect that claim.
So one of the questions would be, if the legislature enacted the law on January 28th and said it was effective today, and Geico had not sought reimbursement, would the legislature have wanted Geico then, therefore, still get reimbursement at the expense of the victim?
Yeah, I mean, that certainly they didn't have to act it. They could have waited. I mean, if you're going to read this as a situation where, they could act for, a year and a half or so, whatever the statute of limitations would be under 39-6A 9.1, they could have waited even longer to assert their claim. And that's one of the things that Judge Ashrafi noted. He said, listen, Geico filed its complaint over a year after the legislature passed an amendment where they said, we want this to be effective immediately. We want to change the priority. It's a simple situation.
So the fortuitous event of Geico deciding there's no rush to file because we think the law is something that makes it irrelevant, that's what determines whether this amendment applies or not. In other words, if they had gotten out of bed and said, let's file now, right after the complaint is filed, we'll file an answer and cross-claim, then the plaintiff would be out of luck?
I think that's an excellent point, and you can see that both ways. Judge, suppose I had waited another year. I have 2 years to file a no-fault claim. I could have waited another year fortuitously. The amendment would have been effective, and now we have the date of accrual, according to Hogler, is after the effective date of the amendment, and I win.
Well, no, you've already filed your
Say I
claim
didn't.
for PIP long before.
Well, suppose I said, well, I have this feeling that there's going to be an amendment. I've been watching the legislative news, and they're going to pass an amendment, and I know what accrual is. I know I think it's the Hogler case.
So you're saying if you waited to start getting medical benefits?
Sure. I mean, we sent that application. Our accident was December of 2009. That application went in August 8th of 2010. This party was devastated by this injury. Nothing happened on this case for 9 months. Now, I have 2 years to file that application. My only point, Your Honors, you're right, some of this is fortuitous, but based upon the decision below, the majority decision, if the accrual date is the date we file the application for no-fault benefits, which is somewhat of an arbitrary date, most dates are to some degree, if I wait 2 years, if I file that on, I could have filed that as late as December 15th, 2011.
And the law would have changed by that time, but that
Yeah.
happens all the time when there's a legislative amendment. Is it people who file later are affected by it? People who
And
file
the point
before
is,
may not be.
their argument is the accrual date, once the right accrues, you can't change it, which I disagree with. But I'm also saying that's an arbitrary date too, in the sense I could have controlled that by waiting to file my PIP application, and then I win. Does that make any sense? either?
You were going to wait to file your PIP application for your injured client?
I could have. Why? We waited 9 months. I mean, they're usually filed right away, but we didn't file. I wasn't even retained right away in this case. I had a young man who's paralyzed in a hospital bed. So all those dates are somewhat
Were
arbitrary.
benefits already being paid, even though the claim had not been filed?
No, nothing
I'm
was
assuming
paid.
when we went into the hospital, they provided the insurance information and...
They didn't pay anything till after they got that PIP application, and the bills
So
were
the
paid.
bills were just accruing?
Excuse me, Your Honor.
The bills were just accruing?
They were just sitting
For
there.
9 months?
Yeah,
And
they
so-
were paid by August 20th. Geico paid them promptly after the receipt of the application. It may have been sent in, they may have had an open file, but if the accrual date, again, it's an arbitrary date to some degree, no matter how you look at it. And I don't even think we get there. I mean, my belief all along has been is, what did the legislature want to do here? They wanted to cure this situation. They wanted to correct the situation. It was a gross injustice
isn't it-
on a very small amount of people, and this is what we have insurance for.
Isn't it also clear, though, that the legislature did not want to make the recovery of PIP benefits dependent upon the filing of a lawsuit? That they wanted it resolved by intercompany arbitration, and that's not promoted if we make the day the complaint is filed by Geico the effective date.
Yeah, and that
I
came
mean,
up.
it's clear in the legislature.
Yes,
in the
that came up in
legislation.
the legislative history,
Right.
and basically the sponsor said, we understand that there will be a delay here, but the insurance company's going to have to live with that. I mean, that was a kind of a minor problem, or kind of one of the effects of saying the plaintiff has to go first. And, that's the way it is now. So if we have a situation like this, the insurance company does have to wait.
What are the total amount of your client's damages? Do you know?
He had...
In terms of dollars?
Judge, he had a Medicaid lien. I don't remember what that was. Some of the settlement proceeds satisfied that lien. They were I would say conservatively over $300,000.
And that was paid by August 20th, you said?
No, they paid $250, exhausted the policy, so they paid most of the bills. And then somehow he qualified for Medicaid, so Medicaid paid bills. And when we did settle the case, I remember we wrote a check to Medicaid.
And I'm sorry, and going forward, what are his expected medical expenses?
Well, I don't know that he's still getting therapy. He's driving. He's back to school. I'm not aware of him. He has Medicare now. This money went into a special needs trust so that he has the use of it for medical expenses such as getting his car adapted so he can drive it because he has no use of his legs, things like that. So that's what the money is used for. I'm sorry, I may not be answering your question.
In very simple terms, it comes really down to, and this is the way it was in Fernandez, whether he's going to get reimbursed for his damages, or whether or not the PIP carrier is just going to get reimbursed for the money that it was obligated to give in the first place.
Yeah, exactly. I mean, when Miss Landrum, his mother, came in and sat down in front of my office, and she said, I explained this to her. She said, I paid for that coverage. I mean, this is not a dispute. The statute gives Geico rights. My rights against Geico, my rights are in tort to get money, my rights are in contract against Geico. And there's nothing in the contract that says we can get our money back, which is kind of an unusual situation.
But the policy is not what's before the court. The
No,
issue,
it's not.
The issue
It's
here
been
is
conceded
retroactivity.
all along that their only rights are statutory.
Right. So,
But,
whether, in terms of whether this is good or bad policy, it's the legislature's policy at the time of the amendment, and really there's a narrow issue before this court.
Well, yeah, I mean, I do think that this doesn't, the decision here does not, or the accrual dates are not relevant to the decision. I think it's very simple. What did the legislature want here?
Let's talk a little bit about curative. Let's say 10 years ago the legislature decides that parties have a cause of action for something. 2-year statute of limitation. 10 years later they say, I think maybe it ought to be 6 years. Is that a curative amendment?
It could be under certain circumstances.
Well,
under
that
others.
doesn't help us.
Yeah,
I mean, what is the hallmark of a curative piece of legislation?
Your Honor, the only way I can answer that is to say that's not easy, and that's why we're here today. This
Well,
is
help
like
us.
putting a piece. I wish I'm trying. It's like putting a puzzle together. It's important that you understand the history since 1983 when the statute was passed, and you all do.
But is a policy change, a change of heart by the legislature, is that curative, or is it a change of policy with different consequences flowing therefrom?
Yes, Your Honor. I'm not trying to avoid the question, but I think I need more information.
So let's try it this way. Can you give us a principal definition of what curative is?
Well, I mean, it's ameliorative. I mean, I can only cite the words from the cases here. It's meant to correct a situation that is not what the legislature intended. There was some interpretation.
Which raises other really philosophical issues, whether or not one legislature really knows. How does it know any better than a court or anyone else what some previous legislature really intended other than the words in the statute?
Well, that's a great point, too, because, I mentioned in here that I think one of
But particularly since the current legislature isn't comprised of the previous
Sure.
legislators.
I think the point was made very articulately by my adversary that, hey, listen, Assemblyman Bramnick wasn't even there in 1983. But what's important is he says this is not what is intended. All right, now he is in essence he's looking at the dissenting opinion in Fernandez when he says that. He's referencing that, but just by the fact that he references it, he's saying this is not what we want.
But how do we reconcile the fact that the legislature waited about 15 years after Knox and David were decided that at least started us on a course down the existing road? How do we explain, if it's curative, how do we explain them waiting 15 years
Well-
and not totally change our statutory construction rules?
Yeah, I think they're busy people, Your Honor, and
I've been there. I know how busy they are.
But I do think that really what got their attention here was the Fernandez case, Fernandez 1 and Fernandez 2. As Judge Long said in her dissent, there's legislation kind of pending here that addresses this issue. So they were working on it to some
But it
degree.
had been the law since about 97.
And
How
that's
do you-
where
how do
we
you
go
explain
back
that?
to the only thing I can say that is, yeah, it's the law if you win the race to the courthouse. I mean, there were so many kind of anomalies there where, the IFA versus Watt case, where the plaintiff collected first. I mean, even if you look at some of the legislative history, I think, quite honestly, whoever said it, I don't remember, it was, Mr. Scuteri, Mr. Bramnick, they're saying, yeah, the insurance company gets paid first under Fernandez if they get there first. Well, that wasn't true after Fernandez. I think we all agree with that. But for a long time, there was this kind of this gray area, and we were kind of waiting. The bar was waiting for it to come up to Fernandez, because I don't know how David could be any more explicit about questioning the decision in Knox.
But it didn't disagree with it, the outcome.
Boy, they came pretty darn close, and you're certainly correct, Your Honor. They affirm, they came to the same conclusion as Knox did, but they said Knox may be subject to some criticism.
So
It could have gone either way.
But doesn't that underscore that the issue was teed up in those two cases it was obviously not only the bar that would be aware of that, but the legislature is also deemed to be aware of that.
Sure.
And yet nothing happens until after Fernandez. So
Well-
what does that tell us? Other than that they're busy and,
Yeah.
and
And they're slow in acting, but when they acted, Your Honor, and they were pretty clear.
Come on.
he's a former legislator.
And you can only take legislative acquiescence so far. In the case of D. Prospero, we were looking at an appellate division case that hadn't been reversed by the legislature, and we reviewed it years later, and we still said they got it wrong in interpreting the statute.
Yeah, that
We didn't argue, well, the legislature didn't do anything in intervening years. We said that they misread the statute, period.
You know, it's just one more piece of the puzzle that I think the court has to look at. But again, I come back to, our guiding light. When the legislature did pass the amendment, and they got around to it, or they felt it was important enough, or the Fernandez case kind of brought it to their attention perhaps a little more explicitly, they said, this is what we want. I mean, we want this to be effective immediately. This is a gross injustice. You can have somebody who's severely injured. There's $250,000 in liability coverage. The PIP carrier is going to glom up all the money, even though the plaintiff, the injured party who paid for premium for that coverage. And
Now, isn't the question of who should be responsible for the medical bills? I mean, you're making the argument that it should be the carrier who received premium in exchange for PIP benefits. But the policy of the statute can equally be, and was under the Fernandez ruling and Knox and David as well, that those responsibility for those bills should first be paid by the tortfeasor or anybody who stands in the shoes of the responsibility for the tortfeasor.
Judge, that's absolutely true, and that's the law. We only get into this situation that we're into today where perhaps unknowingly, or nobody thought of this when the law went into effect in 1983. I don't know. But
at the time that it went into effect in 1983, we can't be unmindful of the fact that there was a crisis going on in the automobile insurance industry. Companies were leaving the state right and left. Geico wasn't even in the state at the time. And the legislature was acting to entice companies to stay without further expansion of JUA-type entities to deal with a rapidly dwindling market. There was plenty of policy reasons for this statute to have been written and implemented in exactly the way that it was.
And apparently that changed in January
And it can change.
2011.
For all the reasons that you've argued, counsel, policy determinations can be altered based upon present circumstances.
Correct.
But I come back to Judge Cuff's question. Is that equivalent to what curative means for purposes of retroactive application of a statute?
I just don't think it's that simple, Judge. I have to answer in the same manner. I can't give you a one-line answer to that question. This is looking at history. It's looking at what legislature said. It's looking at the sponsor statement. In my opinion here, it's looking at the vote.
Well,
which
let me
was
ask it a different
unanimous.
way, if I may. If it's in fact represents a change of policy for whatever reasons that the legislature had, doesn't that mean it's not curative?
No. They could do, quite honestly, whatever they want. And they can say,
No,
listen.
that's not my question. I
Okay.
start from the premise that the legislature can do whatever it wants. And let's say that this court were to interpret the statute, the amendment, to represent a shift in policy by the legislature for its reasons, excellent reasons, good reasons, whatever they may be. Doesn't that by definition mean it is not a curative statute?
And, Your Honor, to further that hypothetical, suppose the legislature said explicitly that this is going to be retroactive. I mean, they could do that.
We're
They
not.
could-
We're not there.
All right.
wouldn't be here today.
So
Yeah, right.
this would be a shorter argument anyway.
Yeah.
But just go. If you could
Yeah.
answer my question,
Sure.
and that is, if the court were to determine that what happened with this amendment was a shift in policy, doesn't that by definition mean that it is not curative for purposes of retroactivity analysis?
I don't think so, Judge. Again, we might
Where's
be-
the
about-
overlap?
What
if you
about the
want-
language, if I could, in this court's decisions in Nelson that says it's not curative if it is to alter the intended scope or purpose of the original act? That seems like a pretty straightforward statement.
Mm.
Do you disagree with that?
I just can't agree with that in the abstract, Judge, that if they're making a change in policy, that there can't be implied retroactivity in that. I understand, we don't always even know the reasons that they make their decisions, but I don't see this as a situation where this was a change of policy, was something new. From everything I've read, this was something, the legislature at least says we never wanted.
So you've described it in shorthand earlier as this is what we want. That doesn't tell us whether it was a clarification or an explanation of the original statute or a 180-degree change from the original statute. Fair to say?
That's fair to say.
So then what should we rely on? We
Well-
don't have any express statements.
Express statements, there are no express statements, but by implication, when you look at this, again, not in the individually, saying, hey, the vote doesn't matter, whether it's unanimous. Mr. McKeon, who's an insurance defense lawyer, saying this is a no-brainer in the legislative history. That doesn't mean it should have been retroactive. But I can only say, Your Honor, when you take it as a whole, it, number one, was curative, that they're trying to correct something that I would submit, and perhaps it's conjecture on my point, that they didn't foresee when the statute first went into effect, that it was going to create this very harsh situation that was going to completely close the door on economic recovery for somebody who had been severely injured in favor of his insurance company.
I'm still having a problem figuring out how this court determines the effect of an amendment on a statute that this court hasn't definitively determined what it means. It's a real problem.
Obviously, the legislature thought they did. We did.
But we
Well-
didn't. But the fact is we didn't. It's 3-3 means it's non-precedential. And now we're skipping over the fact that we haven't definitively interpreted the statute, and now we're applying an amendment. There's something really strange about that.
Let me ask you, I don't know that calls for an answer. Sound like rhetorical to me, but let me ask you a question for
I like
1
that
minute.
question.
Assume for a moment that we all agree, or a majority of us agree, that it's not curative, that is a consideration that needs to be made by this court, and it's not curative. What is the rationale for deciding that it has pipeline retroactivity for all PIP reimbursement claims filed after the effective date of the statute?
Well,
What's
also,
the
Your Honor,
rationale?
we've discussed implied, it can be implied by the statute. That's different from being curative,
Right.
as I understand Gibbons. The third situation is where they talk about the expectations of the parties involved. It's a little bit hard because if you're talking about somebody who has an insurance contract and has an expectation they're going to get PIP benefits, and there's nothing in the contract that says they have to pay them back, and I'm sure Ms.
Well,
Landrum was
when-
not familiar with this statute.
When that complaint was filed, original complaint, the amendment wasn't in effect, hadn't even been passed. But Geico certainly knew that the amendment had been passed, and at least was in effect going forward by the time it filed its PIP reimbursement claim.
Sure, they knew what the law was.
So let me ask you this question
Yeah.
again. What is the rationale for deciding that this claim that there's pipeline retroactivity for this particular claim?
Well, again, I cite the Gibbons criteria. You've taken away something that is curative from me, which is number 2 in the Gibbons decision.
I'm making that assumption.
Yeah. First argument is express or implied. All right, it's certainly not expressed. I think we all agree with that. I say it's very strongly implied by the entire view of this, the legislative history, the history of the case law. Again, the third is the expectation of the parties here. And, again, that may be a hard argument here where I'm dealing with somebody who doesn't know is not familiar with the law. I mean,
But Geico was.
Geico was, yeah.
So they knew the amendment had been passed by the time it filed its claim.
Geico knew the amendment was passed by the time they filed their claim. That's correct. They filed it after the effective date of the statute.
That's what I meant.
Yes.
Okay.
Yeah.
So you're saying their expectation, Geico's expectation would be that it would be under the amended aspect of
Or
the
at least
statute?
No.
Could
Well,
be.
Geico had an expectation before the amendment. Okay? You can argue certainly the expectation of the parties changed because there was an amendment before they filed the complaint, or before that my cause of action even became COA. It was an inchoate action.
Geico knew that the law could change. That's what we said in Farmers Mutual. It's a highly regulated industry, and the rules are not unalterably fixed. And you're aware it may change, and it's going to affect your expectations.
Sure, and there's a manifest injustice argument, but this is, again, we've seen the courts act in other situations where rights had accrued technically, the palimony matter that was decided. Kornblatt decided these issues. I think Phillips decided in my case where there was legislation that arguably eliminated a case of a National Guardsman who was severely injured.
But in Maker, we're talking about a situation where the legislature acted.
Correct. It's always the legislature, and the court's interpreting the legislature.
To
I may have
affect
misspoken.
to affect the rights of the parties.
Right.
Of
Kornblatt
what category?
was the same. White that's the hospital case where they changed the amount, the ceiling or the basement on charitable immunity. They raised that. So I think all of those cases, they're all legislation. They're not where the court is changing the law, but the legislation is passed and it changes the rights of people, and it's retroactive in some instances.
Is it your argument that the expectations of parties is always consistent with retroactivity because parties have to understand that the law could change? Do you see what I'm getting at? Are we talking about
I'm not sure I understand that.
Are we talking about a specific situation here, or are you essentially arguing that because legislature had the ability to change the law at any time, that any party at any time expectations had to be that the law might change?
I think what they're addressing there more has to do with, and it ties into the manifest injustice argument, but I think what they're saying is that where somebody acts in accordance with a specific law, you don't want to pull the rug out from under them. And I think Judge Ashrafi mentioned this in his dissent. Geico, they didn't do anything different because of the amendment. They had to pay no-fault benefits. I mean, they didn't rely on this. If they came forward with somebody and said, we had to raise rates,
But
by a
let me ask it
dollar.
a different way, because I inarticulately asked the question. My question is, what is the expectation of the parties for purposes of retroactivity analysis? Isn't the concept that the expectations of the parties were such that the new amendment to the statute would apply to them, as opposed to a general expectation that parties and people in general might have that the law might change in some unknown way at any time?
Well, I think that goes not so much to what we expect will happen in the future, but it goes to our conduct based upon the current law. And
where is that though? Is that content of the expectation of the parties prong of retroactivity analysis really in the law, or are you extrapolating from that?
Well, I think that's mentioned in some of these cases.
Isn't it different for It's different depending upon who the party is and what the law is. I know you cite Maker, but Maker's really not a good fit here because it was dealing with an understanding of the statute of frauds. We're dealing with an insurance company, which is part of a highly regulated industry, different than individuals. And we have said that those businesses have and I'm quoting, have no contractual expectation that a naturally fluid regulatory scheme subject to change at any time will remain in an unalterably fixed state. They're in a different position than other people because of that.
Yeah, that's clear that if you're going to be in the insurance business, you shouldn't have expectations. I mean, that's what the
But isn't the
case law
presumptive
says.
rule that legislation is given prospective effect? I mean, don't we start with that as the beginning point of any discussion of legislation, unless we deal with one of the express or other categories for retroactivity, we deal with prospective application. And here they said effective immediately. So it adds further evidence that we're dealing with legislation that is applied on a going forward basis.
Well, I would cite the twist, Your Honor, which says this is not a hard and fast rule. This is, legislative intent is what matters. It's only a tool. That's what twist says. It's not like this is a irrebuttable presumption or a presumption of any kind.
So now
It's
we
just a
have no
tool.
presumption about legislation about whether it applies prospectively or retroactively?
Not according to twist. I mean, the general rule is it's assumed to be prospective.
That's
We have the Gibbons test, I would agree. But,
Okay.
again, this is not...
I know you're having a little trouble agreeing with with that
Well,
proposition, but...
I can only say what Twist says. Twist says, I could quote the case for you, I have it here in my notes somewhere, but it basically says, this is just a tool.
Doesn't it also depend, it depends upon whether or not the starting point is the filing of your PIP claim or Geico's claim. And if it's Geico's claim, then it's prospective.
Sure.
They hadn't filed anything yet. And because they hadn't filed anything, they weren't entitled to anything.
Well, it gets
So
back-
therefore, what was cut off by the fact that the amendment went into effect?
Gets back to the expectations of the parties. What are Geico's expectations? They had to pay PIP coverage. That was not optional for them. It's not like they did something. If I go out and I get a liquor license, and I'm promised that there's only 10 liquor licenses in Trenton, and I rent a store and I buy stock, and then a law comes up that eliminates anybody can sell liquor in Trenton. Well, I've relied on that law. No, I've taken affirmative steps. That's what they're talking about, I think, when they say expectations of the parties. We don't want to pull the rug out from anybody, but on the other hand, that's not the situation here. Geico had a contract. They had to pay a benefit. A statute was passed that said, listen, you don't have priority anymore. They file a complaint a year later. The case settles 6 months later. What were their expectations there? I don't think that this is something, the insurance business is a fluid business, and I would respectfully submit to the court that they should not have had high expectations or any expectations. And if they had them, they were eliminated when the statute was passed, effective immediately.
Is there anything you'd like to add to your argument?
Nothing, Your Honor.
Thank you.
Thank you.
Mr. Turpin.
May it please the court, counsel, good afternoon. Just very briefly, it's Geico's position that the majority below correctly decided the issue before it, the very narrow issue before it, the retroactivity of this particular amendment. We believe the court correctly found that it's not meant to be applied retroactively. It's meant to be prospective only. The court correctly found that the legislature did not express its intent, either expressly or implicitly, that it be applied retroactively. The majority found below that correctly found below that it was not meant to be curative. It's not meant to be curative because the amendment did change the law in a substantial way. The court correctly found below the expectations of the parties also did not warrant that it be applied retroactively. Finally, the court found below correctly that the claim, Geico's claim, arose upon the filing of the PIP app, which was the accepted law at the time and still is. And therefore, at that time, the prior law under Fernandez 1 and Knox and David, as the court has discussed earlier, applied, and Geico's claim did take priority. So we contend that the majority below made the correct decision and should be affirmed in this case.
So Geico files its claim February of 2012.
Yes, sir.
Which law should we look to determine its rights as of that moment in time?
You should look for the law that applied at the time the claim arose, which is well established is the date that the PIP application was filed by the plaintiff.
But do you think that's what the legislature intended? That the legislature that passed that law on January 20th, 2011, its intent, wanted Geico, which had not filed the claim, to get reimbursed at the expense of the insured?
I believe, Judge, that if you look at the statute and you look at the case law, had the legislature intended what Your Honor is suggesting, they could have done a much better, they could have made that much more clear in the statute.
Maybe they could have, but they said effective immediately, now.
But that doesn't necessarily mean, Your Honor, respectfully, that it meant to apply retroactively. Effective immediately means it applies as of that date.
Right,
forward.
assuming that they intended to bar Geico, if it hadn't filed a claim, from filing a claim for reimbursement. This is it. They said, here's the law now, and as of this date, the PIP carrier doesn't get reimbursed at the expense of the victim. And then Geico files its claim after that law goes into effect. Doesn't it seem as though the legislature would not have wanted that result?
Judge, I would disagree with you on that. Again, that's certainly what the plaintiff would want, and I can gather that's what Your Honor would like to see.
I'm just reading the amendment and the dates and what follows.
Correct.
And the fact that they passed this law, and they didn't want they wanted the victim to get reimbursed, and they certainly in priority before the PIP carrier, and the PIP carrier hadn't been reimbursed. They hadn't even filed their claim. So,
in terms of the claim, when it occurred, I mean, the law clearly, I think, is and was that it arises when the claim arises, Geico's claim arises when the PIP application was
So
filed.
if the plaintiff had chosen to wait until the eve of the statute of limitations, I hear the statute's pending, law's pending, it may pass, I'm an ultra-shrewd, legislatively savvy plaintiff's lawyer, I'm going to wait to the eve of the statute of limitations, maybe the law will be passed and I'll get in. If they had done that and waited right up to the 2 years, would they be entitled to recover, the plaintiff?
Potentially, Judge, but that's a
Oh,
situation.
not potentially. What's the answer, yes or no? From Geico's standpoint.
From Geico's standpoint, if they had filed it,
After the effective date of the statute, the amendment.
correct. Geico would then have 2 years to file their.
That's not what I asked.
Right.
Who gets paid first, the plaintiff or Geico?
As I understand the reading of the law, at that point in time, the plaintiff would have priority.
What are the consequences if we were to say that Geico's filing of the action in February 2012 should be considered in light of the amended statute? Are there consequences beyond the fact pattern in this case?
I'm sorry, Judge, I missed part of that question.
What's the import
The import of this?
from Geico's standpoint? If we
From Geico's standpoint, the PIP system is set up so they have the opportunity to recoup their costs in certain situations. And so that's the import. They want to get the system set up for them to recoup that
I think the
money.
question is, are we dealing with a class of one case here? Are there more cases other than this one? We have one fluke case here?
I don't know, Your Honor. I don't know.
You're
I'm not aware of any others.
You cited before that the standard law is that you consider the accrual date the significant date, and accrual has been interpreted under this law and generally law under similar statutes as being the date on which the statute of limitation begins to run.
Correct.
What would be upset if we did not follow that rule in this setting?
What would be upset? I mean,
Yeah.
it would change everything. It would change any type of claim that a 9.1 claim that a carrier may have. It would basically creates a whole new statute of limitations.
Right. It would delink the analysis for accrual and statute of limitations purposes.
Correct. Yes.
Which would have broader implications
Oh my gosh, yes.
than this
Much
statute.
broader, yes.
Which is presumably why the majority applied that settled approach to law in this particular case.
I would agree with that, Your Honor, yes.
Any other questions?
No.
Anything you'd like to add, counsel?
No, sir.
Thank you. We'll take the matter under advisement. Thank you, counsel, for the helpful arguments. Court's in recess.